Thank you, Representative Koppelman, Mr. Speaker. Good afternoon. I'm going to lead off, and I'm going to try to be brief so that my two colleagues on the panel will have a chance to talk. And then I hope that we hear some questions and comments from some of you people. There are at least three people here that have not been mentioned before that are very significant in the legislative and executive relationships from the judiciary standpoint, and that's our state court administrators. And I know Patty Tobias from Idaho is here, and Lilia Judson from Indiana, and Sally Holova from North Dakota, and there's a representative from the state of Washington, Administrative Office of the Courts. And so they obviously will have some insights into this. When we were asked to do this program not too long ago, the subject apparently was raised by the judges, that some judges that were concerned with the ethical considerations that are involved in interbranch relationships. When I was told that, I had to do some speculation as to what those concerns might be, since I did not have a chance to talk with them directly. But most judges in most states are governed by a code of judicial conduct. There's a model code put out by the American Bar Association, and I expect, although I don't know that most of the states have worked off that code. They may have modified it somewhat, but in most respects, the provisions are essentially the same. And there are just about three canons that I want to draw to your attention. And one is Canon 1, that the judges are bound to uphold the integrity and independence of the judiciary. Canon 4C, which I think speaks most directly to the issue that Chief Justice Cobb and some of the speakers earlier today touched on. And I want to read you North Dakota's version, which I think is very close to what the model code is. And it says, "A judge shall not appear at a public hearing before or otherwise consult with an executive or legislative body or official, except on matters concerning the law, the legal system, or the administration of justice." Now, what Chief Justice Cobb and the Alabama delegation talked about this afternoon were all matters that touched on the administration of justice. There's no doubt in my mind. I would draw the distinction then for you between the adjudicative duties of a judge, that is, the duties to decide a case impartially that comes before the judge, and the administrative duties, which are certainly not bound by the same code of conduct as the adjudicative duties. I'm going to give you a little example. This happened in North Dakota, and my colleagues can correct me on the time. About 15 or 16 years ago, we had a school finance case. It came before the court, and three of the justices held our finance law, education finance law, unconstitutional, and two of the justices said it was constitutional. North Dakota is a populous state, and the branch of the government that represents the people most directly is the legislative branch. And so in our Constitution, we have a provision that says it takes 4 of the 5 justices to declare a legislative enactment unconstitutional. As a result of that decision, the 2 justices that dissented became the majority, and the 3 justices in the majority became the minority. I was one of the justices in the minority, and I wrote a special concurrence. And in that special, I wrote a dissent, and in that dissent to the majority opinion, which in essence I upheld the finance situation, but I pointed out many of the weaknesses that were involved in our system, and I tried to point out as explicitly as I could where I thought the weaknesses were. Subsequent to that, several legislators, and most of them now are no longer in the session, asked me, well, what do you think we should do? It was a case in which I had to say, all I can ask you to do is read the opinion. I really can't tell you what I think you should do. I think that was a turnoff to them, and I understand it. But I believe that that's what our code of conduct requires, because it was an adjudicative function. So there are other areas. The Canon 5, which a former panel touched on, and that deals with the political activity of judges, and that's been under attack for a long time. Our legislature set up a study committee, an interim study committee, 2 sessions ago to look at it, and they did, and they didn't do anything because we haven't had any really contested issues in North Dakota, and there wasn't a problem yet. I hope one doesn't come along. But that canon on political activity is also something that might be a barrier to relationships. But I think Canon 4C is the one that we deal with the most. I again draw the distinction between the adjudicative and the responsibilities and the administrative responsibilities. I've urged our judges, both my colleagues on the Supreme Court and the District Court, to follow the canon, to obey it, but not to use it as a shield, and not use it to refuse to answer or duck the hard questions that might come up with the administration of justice and in the administrative part, as opposed to the adjudicative part. Except for the one instance I gave you, I have never had a legislator in North Dakota ask me how we were going to decide a case or what we were going to do. They just simply don't do that. So it hasn't been a problem. They've asked me some tough questions on budgets and some other matters when I've been before the committees, and those are fair questions, and I'm not going to duck them by saying I can't answer because of the code of conduct. So those are some of the things that I wanted to talk to you about. The other part of the panel, and then I will defer to my colleagues, deals with building relationships, or the relationship between the branches. And I think honesty, integrity, and candidness are the cornerstones of that relationship. I have worked hard to establish those with our legislature. I think I've been fairly successful, and with our executive branch. North Dakota has the provision that our budget goes directly through to the legislature. It does not have to be approved by the governor, although he includes it in his budget. But I discovered early on that was a phantom, a phantom privilege. I recall very clearly one of my first legislative sessions after I was chief, in which the Appropriations Committee, or one of the members, said to me, well, that budget hasn't been vetted by the Office of Management and Budget. And so it was, very frankly, suspicious on arrival. I went back to my finance people and I said, I want you to work very closely with the Office of Management and Budget. Ultimately, we will decide what goes in there, but I want them to know what's in that budget. And I think that has resolved a lot of questions, not all of them, but a lot of questions that have come up with regard to the budget. So, and of course, candidness and credibility are two-way streets. We try to be candid with the legislature. I hope that they are, and they have been, candid with us. If they don't like something, they tell us, and I don't mind that. That's what I want to hear. I want to hear the reasons why, and I want to know what we can do. But it's the type of direct relationship that I think builds trust and confidence. And after all, we are all working towards the same goal, and the same goal better be service to our citizens of the state, in my instance, the state of North Dakota, and in your instance, the citizens of your state. If that's not your goal, then maybe you aren't where you should be. With that, I'm going to give it over to Lori, and she will give the legislative approach.
Well, thank you very much. I always learn a lot when I come to these CSG events, and one thing I learned today is that a cannon is not only something you shoot. It's something that guides more than just a ball of lead. And so, I always learn so much, so I appreciate the judicial education I've gotten here today. I'm just going to make a couple comments related to ethics. Ethics are something that you really don't talk a lot about, you don't think a lot about sometimes, and you ought to. And when you don't talk about it and you don't think about it, you end up talking a lot about it very publicly and thinking a lot about it reactively because something happened. And so ethics are something that we need to be talking much more about and thinking much more about before we read about it in the newspaper and along the way. Others' ethical lapses, it doesn't matter which branch of government it is, those ethical lapses potentially have an impact on you as an individual in the short term and have what concerns me, which is a longer-term impact on the institution itself and on the cynicism that we all face every day in the jobs that we do as a public servant. So those ethical lapses are extremely important for us to be paying attention to. Obviously, people are served best by three branches that communicate, collaborate, and cooperate while keeping their independence. And the one thing I'd like to remind myself, and this opportunity here in North Dakota is a great example of the foundations, and it's not about turf. The three branches are not about turf. As much as we sometimes forget that it's not about turf, we think it is, but it's not. It's about protecting liberty and safeguarding liberty. And that's something that I think each and every one of us should remind ourselves of every day as we get into difficulties with other branches of government. And ethics can be as small as an action, small as a statement, or as large as a culture in the organizations that we belong to. And it doesn't matter whether it's a house or the judiciary or an executive branch or just an organization that we belong to in our own private lives. We all know ethical organizations and we all know unethical organizations, and that culture has multifold implications that we probably don't know of for years. So related to ethical considerations between the branches, I just wrote down a couple of things. That was my soapbox. I'm now off it. But a few things. I think we need to recognize that each branch, we need to make sure that we recognize each branch's importance and the specific purposes of those branches and do a better job focusing on that. I think we also need to create a better understanding or focus on understanding that the other branches are actually relevant and crucial and play a role. And that role cannot be played alone. We're part of the same team, whether we like it or not. It's like family. You can choose your friends, but you can't choose your family. We're all part of the same family in some way, shape, and form, and we impact each other in so many ways. Knowledge. Understanding the ethical implications of the judiciary or the executive branch is absolutely something that I, as a legislator, ought to be doing, but I can pretty well... We don't think a lot about it. That's something we should know. We should know, each branch should know what the ethical requirements, the ethical implications, and what are those parameters that the judiciary or the executive branch have to deal with. If we don't know what they have to deal with, we might be putting them into a position that we wouldn't want to be put into ourselves, maybe even unknowingly. And that's a scary thing in terms of building trust. We had a very public situation happen in Minnesota 2 years ago. And it was a situation that I think it started out innocently enough with a legislative branch, legislative person, I'll say, making a comment to a group that he was out visiting, generically he, but it's actually rather public. But he was out making a comment to this group and says, related to some legislation, don't worry about it, essentially. I'm paraphrasing, but don't worry about it because I've talked to some of the judiciary and they're telling me that, it's going to be okay. I've talked to these folks about this issue and we just shouldn't be worried about the opinion that's going to be coming forward. Now, it's a very public situation. And all the details are out there if you want to look at it. But the frame I want to put in place for us is that sometimes we say things which serve our purpose at the moment. That served the purpose of getting that group off this person's back temporarily. So that served the purpose. But in doing that, I think that there was there was just a stepping aside or a forgetting that you're then putting an entire branch at risk. That communication, that direct communication which was portrayed by this person was such that it calls into question that separation between the two branches. And you're going to get stories on both sides related to who said what, who didn't say what. But the fact of the matter is that that question and the public airing of those questions impact both the legislative and the judiciary in that case. You had the judiciary come out and say, no, we didn't have those discussions, we didn't make those statements. The other side saying, well, I have witnesses saying you did. And at some point you have a legislative hearing saying, okay, we need to call the ethics into question, but you can't get the judiciary sitting at the table because they're independent. So there's all sorts of things that happen with a simple, maybe it was a misstatement, I don't know. Maybe it was an intentional statement. I don't know. I'm not going to judge that. But the result was negative. The result was something that impacted both bodies significantly, not just both individuals, because it impacted the individuals as well. So just that's kind of a real story about how I think that we need to make sure that we're not just saying things to serve our own purposes, but also recognizing those parameters that the other bodies do have specifically related to the canons of the judiciary and the requirements that they have in terms of their own independence. I think that that's a good lesson for us all to remember. So, one thing, Chief Justice Cobb said something about the judges like to talk about divorce or something along those lines. Those are great cases. Well, I think of the separation of powers as separation, not divorce. Oftentimes we prefer to consider it as divorce. We don't want to talk to that other body. They're their own separate thing. They just get in our way. They cause us trouble. All these things. But we aren't a divorce of powers. We are a separation of powers, which means that we do need to interact. We do need to figure out how to facilitate things to make them work better. And we do need regular and both formal and informal communication between the bodies, whether it's all three branches. And so I just want to make sure, you open the door, Chief Justice, and so we got to think about it in those terms from my opinion. Informal communications, not just when you want something, not just starting those communications after the fact. I think that's something that we don't do enough of as public servants, is starting the small communications, that relationship building. I think Senator Coughlin talked about, this is a relationship business, and if you wait to build that relationship until you got to have what you need, it's too late. So building it from the start, just a simple thing as saying a hello in the hall and building it up to a collaboration between the bodies and the branches is extremely important, and something that we should all be much more intentional about, from my opinion. We often get so busy and we're running in the hallways in 4 different directions dealing with this committee and that committee. But the fact of the matter is that I think we do need to be more intentional about how we think about the other branches, and the fact that you're here today tells me that you are. And so we need to kind of spread that message to our colleagues, and have ourselves start thinking about things a little bit differently, thinking about how it might portray or how it might impact the other body is difficult, frustrating, but it's probably pretty important. I was always taught when I was younger that the best way to succeed in a debate is to know both sides of the debate before it occurs. And it's the same thing with between the branches. You got to know what's going on in the other branch to be able to make things work. Lastly, I just wanted to make a point that ethics are not an excuse. We often will make an excuse that, I can't go out. We have ethical rules. In Minnesota, we have very tight ethical standards related to what we can and can't accept. But relationships aren't necessarily about who's buying the beer, or relationships aren't necessarily about whether you can go out on the golf course or not. You can build those relationships around the ethical parameters in each one of our bodies. And I think that we often use the ethical rules as a crutch to not do what we ought to be doing anyway, just simple relationship building. It's about the golden rule. It's about getting to know your colleagues and getting to know the people who you don't necessarily work with all the time. I think a lot of times interbranch collaboration and communication starts from the top down. And, you have negotiations between the leaders and the other branches in the executive branch, and you have the judiciary coming in and talking to the chairs. But I think what we need to do a better job of is going from the bottom up and starting to get some of those legislators and start to create that collaboration and communication between people in the early years of the legislature as well. Because then you're building a long-term commitment to that collaboration, which I think will value everybody. So thanks so much for being here, and I hope we can have a nice exchange. And I want you to be thinking about this question: what is ethics? Think about it. We've got to start asking ourselves things like, what is ethical? Who are the people that we find ethical, and why? What are the parameters that we think create an ethical human being? I think we've got to start asking our own selves those rhetorical questions before we can figure out how we fit within those. Thanks.
I'm going to touch a little bit about the relationship between the executive branch and the legislative branch. But I have to tell you, it's a little daunting standing here and looking across the room and seeing a lot of North Dakota legislators, and they're sitting in their own respective seats. And I may have a budget coming up here in January. But I just have to mention, everything that the Supreme Court Justice mentioned earlier about honesty, integrity, and candor. That's one thing in North Dakota that we do have. And I honestly don't know how you can get to an executive spot without having a little bit of background. I didn't come from the legislative background as many folks do to the executive branch, but I came from a different perspective. And I was privileged enough to serve as a committee clerk for House Appropriations on the session before I ran for office. And I quickly learned there's a lot of perception, but I also quickly learned that you can get 3 answers from the same question. What time is it? Do you have the time? Yes, I do. No, I don't. Or it's 2 o'clock. And those are some of the things that I quickly learned when I did become an elected official, when trying to communicate that information to the folks that needed that communication. And for those of you in this room that know me, I'm very candid. And so I think that's part of it. When we talked earlier, we've heard words like misunderstanding within branches, lack of communication, and even lack of orientation. I don't know about some of the other states, but here in North Dakota, we don't have an elected officials 101. I don't know that we have a legislature 101, where you actually go in and you are given an idea of what the critique and the ideas are relating to relationships or relating to ethics. And so you go to your peers. And I can tell you as a state treasurer, my peers at some times have not been the best place for me to go relating to ethics. I mean, we have a treasurer in New Mexico who's no longer a treasurer. We have a treasurer in South Carolina who's no longer a treasurer. We have a treasurer in Arizona who's no longer a treasurer. And they were all related to ethical issues. So I think in some cases we need to address that within our own branches to have some type of orientation and to just start to define and bring those ideas into it. And I will take that one step further, Representative Koppelman, and when we have our new Treasurers Symposium with the National Association of State Treasurers Foundation in December, we will definitely begin an orientation among interbranch and see if we can bring that to the table and start getting our treasurers up to speed on that. So we'll take it one step further. As far as the relationship side, I can tell you that I have been very blessed to have the relationship that I do with all of the legislators. I remember after being elected, a senator who I've always respected from, I might add, the opposing side, came up to me and congratulated me and said, "Now, Kelly, you need to remember that when you walk in this building, you represent everyone." And I very quickly took that to heart because that is true. As Laura mentioned, we're all on the same team. It's about doing what's very best for the people of our respective states. And it's not about being right, it's about doing right. And sometimes when we put aside those personalities and those whole other issues that come along with being right, and we sit down and we work together, it's amazing how things come. And that's where we get to the communication side. I've quickly learned that on some levels, we're not the experts in our office, and I find that very interesting sometimes, because if someone wants to write a law or work on an issue relating to something that my office does, who better to come and ask questions to than the folks that are actually doing that? And I think sometimes that communication, not only does it give us an opportunity to share what we do and maybe educate on the other side of the table, but also an opportunity for us to learn from that legislative side of the table, maybe an idea that we hadn't thought of or something that we don't see. You know, it takes every cog in the wheel to make the wheel turn. And I think by working together, we can move that wheel along a little bit. There was a discussion earlier about legislative intent. And I can tell you, sometimes working on the fiscal side of things, there have been times where we've called legislative council after everyone has gone home and said, we were not able to be part in the hearing process. Can you tell us, you know, what is this all about? Or we've actually called legislators and said, when you drafted this bill and it became law, what was your intent here? Because there's a little bit of question as far as doing it to the very best of our ability and doing it in a true way the legislation was intended to do. And so sometimes I think that whole communication can come back to that, just that discussion. Another thing that I've noted by watching is accessibility. You know, perception is everything. And if you truly want to develop a relationship with a branch or with different groups of people, you need to make yourself accessible. And some do it one way and others do it another. Myself, I have tried very hard to make myself accessible with the legislative process and with my fellow colleagues. And you know, that was a misunderstanding that I had too with the judicial branch. I didn't really know I could talk to you guys. You know, in the sense that there was a dialogue, because there's always been that wall there. And once again, there hasn't been an orientation. So unless you have the opportunity to come and to listen and to find out, you know, I'm not the only one that was thinking that way. And sometimes we're so afraid of being perceived that we don't understand the question or that we don't ask a question because we don't want to admit that we don't know the answer. So I think many times we just need to get back to that old-fashioned communication kind of thing. But on that note, I think we're going to open things up for questions. But I can tell all of you that North Dakota is very different in how we do a lot of things. And the one thing I have seen and learned is that when it's all said and done, I have seen many disagree in this chamber and walk down that hall and go to lunch together. And that's North Dakota.
Thank you. Thank you, Chief Justice VandeWalle and Representative Broad and Treasurer Schmidt. Excellent job. This is billed as a roundtable discussion on our agenda. So while we certainly welcome questions and our panel will attempt to respond to those questions, I don't think we need to limit it to our panel. So if questions come up, or maybe you have a comment, or maybe someone asks a question after this that you have a response to, I think all of us can feel free to engage in that. I see a hand back here. Yes, Senator.
Yeah, if you don't mind me being provocative again. In Kentucky, we've had a little run-in with Interbranch Conflict recently in our session. In the first instance, we created by statute an administrative office of the courts designed to provide administrative support to the Justice Branch, and for some reason included in there that the Senate would have the right to approve the director of the administrative office of the court. And then we also decided, we've been going through state government looking correction workers, social workers, people whose pay was so low that maybe they needed a little bigger boost than the annual cost of living increase. And we got to the deputy court clerks who are employed by this administrative office of the court, and we were very definite that we wanted this group to receive a significant boost to get them up because their salaries were so low. And to our surprise, the Chief Justice said, I don't care if you didn't approve my director of the administrative office of the court. You don't have the authority to do that. So I'm going to just keep him there even though he wasn't approved by us. And then turned around and said, and by the way, we're taking all that money you gave us for the clerks and we're going to spread it across the whole pay, and we're just not going to follow that dictate. So if you don't mind, Chief Justice VandeWalle, any comments you might have about that, and then maybe the legislature could tell us how.
I have a lot of comments, Senator. Believe me. I don't know what your Kentucky Constitution says. So in North Dakota, our Constitution says the state court administrator is appointed and serves at the pleasure of the Chief Justice. So obviously you could not do in North Dakota what you did there. I have no idea what your Constitution is. But I do think, by the way, you're not one of the original 13 colonies, are you? The reason I ask that is that I've discovered that separation of powers was really only an idea in the original colonies. If you look at the original colonies, and anyone here from Virginia, in Virginia, the legislature elects the judges. They stand for election in the legislature. I was aghast when I heard that. I thought, my goodness. But the concept of separation of powers was not really fully developed. And so North Dakota is a pretty new state, 1889. So separation of powers had come a long way by that time. But I will be candid. I would say that, yes, I think it is the responsibility of the judiciary to set the salaries for their people any more than within the limits of legislative appropriations. And our legislature tells us very clearly what they expect to give, but for the FTEs, and so we follow that within legislative appropriations. But we raise some salaries and we don't raise some others, and we do those types of things. So I can understand the reaction of the Chief Justice in that instance. Again, not knowing what your Constitution says with regard to the appointment of the state court administrator. I have no idea. It's purely a statutory provision, I guess.
It was purely statutory, and I actually am a very strong opponent of each branch having its own power. And when I first heard that, I said, well, yeah, what are we doing approving his employee? But I was a little bit more taken back by the situation with the clerks, and maybe I could ask our executive or legislative panel why we would have the authority to set the pay for the treasurer's employees, but not for the judicial branch employee. If you all would maybe be able to make some kind of distinction there, and perhaps yourself, Justice.
I suspect that Kelly will respond to that. Again, we're all creatures of our own local situation, and we don't always understand what happens in other states. But Kelly, do you want to respond?
Well, we too are set, but we do it within the confines of what's been given to us by the appropriation process. We have our non-classified positions, which of course we can kind of move through, but everything's based on a classified sect, and we work within the appropriation of what we've been given. I mean, I think probably the same as what you would do. So that's how we, though sometimes we'd like a little more.
Not so sure about what that might have been out of order.
Get the speaker riled here, we'll all be in trouble. I have a question that I'd like to pose, that being a little bit provocative here, or probing as well, on the issue of ethics. All of us in North Dakota, as I think we've already mentioned in the legislature, are part-time, and we all have other jobs or businesses. I own a business, small business, and for years I was involved in an ethics, they called it a business ethics luncheon that one of our local college business, schools of business, sponsored. And we had different speakers, and I was actually asked to be a speaker once, and I would come and hear other speakers. And I remember an attorney came to talk about legal ethics. And I don't want to pick on this attorney, but I was a little bit shocked, because it became very apparent in that individual's presentation that, I'll say, I guess I can't get away from saying she. It happened to be a female attorney, which is neither here nor there. But she went through sort of a litany of things that are, this is what you need to do to stay out of trouble. To keep from getting sued as a business person, et cetera, rather than what I always thought ethics were growing up, which was basically the difference between right and wrong. And what's occurred to me in recent years in the business community, and it's crept into legislature, state government, the legal community, etc. As we create codes of ethics, oftentimes they are lists of rules or regulations rather than, in some cases, really bear no resemblance to what we might all consider right or wrong based on our moral ethics or moral code. And I'm just curious what your thoughts are about that. And I'll give you an example. I think in your state, Representative Broad, I don't know if it's legal to buy a legislator a cup of coffee if you're a lobbyist, or certainly not a meal, because it's been deemed inappropriate. Now, I don't know that there's anything morally wrong with someone coming and saying, hey, can I take you out to lunch? And I certainly don't think your vote is for sale for the price of a lunch. However, we've taken that and made it a canon or an item of ethics. On the other hand, there are probably certain things you could do that wouldn't violate a written code of ethics at all, but you sure wouldn't want that to be on the front page of the newspaper tomorrow. So maybe you might consider it being wrong, morally wrong. It may or may not be ethically wrong. And I guess what I'm asking is, I thought those two sort of meant the same at one point in my life. I'm beginning to hear a lot of definitions that separate them. Comments from our panel, or actually any of you on that? Go ahead, please.
Well, I don't know. Actually, I'd like to hear from some of you guys, but it seems to me that they're very different. We all have our own moral code that we go by, and it's going to be different than the person sitting next to you. There's some fundamental things I think that we all believe in as human beings, but I think that the business side of it, what you bring out, Kim, is absolutely more about regulation and following the law than it is about ethics. I think the ethics discussion has really been more in line with right and wrong, in my view, and we've skewed the discussion into a discussion about what is following the law or not following the law. So I would suggest that they're very different things, even though in our view of how we ought to operate, we view them similarly. In Minnesota, we are not allowed to accept anything. And I know that whatever you buy me is not going to change what I believe in, my fundamental philosophies, but perception rules the day. And I think as public officials, we need to be very cognizant of the perceptions that the people have over what we do or don't do that might be proper or improper. So I think we have to be exceptional in our in following the law, and exceptional in following the ethics, because the results and the impact to us individually and collectively are significant.
Well, and I can add another layer to that. In the financial sector, we're reading things about CalPERS, we're reading things about different groups and things happening, and we have a code of ethics with our state investment board, with the land board, and different boards that I serve on. And now as we work through our audit process here in North Dakota, we're developing code of ethics within each state agency. But I'll tell you, it is extremely difficult when you're working with financial institutions. For example, I facilitate a program here in North Dakota. Through a bid process, we place dollars in different banks and credit unions across the state. Well, I came time to refinance my mortgage, and I was going to go to my local bank, but we had state money in my local bank, and I contacted my attorney general to make sure it was okay that I put money in that same bank, because you always have to make sure you know the line, and you can't get close to the line. But as you move, especially in the financial sectors of what's going on, we have had a lot of treasurers and a lot of board members on different teachers' retirements and different things like that have really stepped up way too close and sometimes stepped over. And it is about perception. But everyone that's doing this needs to know there is right and there is wrong. And you need to never get close to the line.
We've talked a lot about accepting and what's right and what's wrong, and I need to point out some distinctions between the branches. Certainly, I don't think anyone would consider it inappropriate for a legislator or an executive branch official to serve on some committee to solicit funds for some public purpose. Not true for the judiciary. We cannot go out and solicit funds and say, will you contribute some money to the new swimming pool that the community is building, or will you help the YMCA that's being built? We can't do that. Legislators and executive branch officials can and probably should do that. We can't. And the reason we can't is inevitably, someday, some person that's contributed is going to come before that judge, and the issue is going to say, I contributed to the, you asked me to contribute to this fundraiser campaign, I did, and so even though that party doesn't say it, the expectations are going to be, so I've got a leg up on the other side because I gave money when you requested me to and the other party didn't. So there are some distinctions that I would like to point out in that regard.
Thank you, Jerry. Let me ask one other question. It's a little bit of a probing question and deals with the courts a little more directly and your code of judicial conduct, or whatever it's called in other states. I realize the name might be different. The White case, which I believe Senator Rest talked about and others have alluded to, was really a landmark case. And here in North Dakota, we've heard from our judges about concerns about that. We have nonpartisan elections in North Dakota for judges. But certainly that case implies that if a party wanted to endorse, if a judge or a judicial candidate wanted to seek endorsement, they could. And I think we understand where it came from. I have a good friend who ran for judge, and he said he's an attorney, and he said it was the most frustrating experience of his life because he would go around and campaign and knock on a door or meet someone at the county fair or whatever it was, and they would say, well, how do you feel about that? And he would say, well, I can't tell you. Well, okay, well, what's your position on this? Well, I can't tell you. Well, why not? You're running for judge. You're asking for my vote. Why can't you tell me? And we as legislators understand that frustration. And he would say, well, because my code of judicial conduct prohibits me from disclosing how I might feel on an issue. And I think what it really prohibits is that you can't disclose how you might vote on an issue that might come before the court. But of course, you can make the argument that any issue could conceivably come before the court. My question is this: the code of judicial conduct seems to be so ingrained in the minds of lawyers and judges that it almost supersedes. I found a supreme irony when I watched the White case, because as legislators, we're used to seeing cases go up to the U.S. Supreme Court, and we're used to seeing legislative action, oftentimes it's the action of the U.S. Congress, overturned. And everyone tends to nod and bow and scrape and say, okay, the court has spoken, and now that thing is end of story. Unless we change the U.S. Constitution, end of story. Yet with the White case, I found it very interesting that it was the courts that were saying, we don't like this Supreme Court decision, and we want to rattle this tree a little bit and see if we can change what the court said. I was talking to a person who was running for judge during the time that decision came down, and the local code of, or the local powers that be in the judicial world came out with a comment, the committee that governed that, saying, well, we realize what the Supreme Court said, but we haven't changed our code of conduct, and therefore this is what we still expect. I know it's a probing question. Those of you in the courts, Chief Justice VandeWalle or others, comments?
Well, let me start. Minnesota versus White, and I don't like the decision, and I've told the legislature I don't like it, and it's there. We did have to change our code of judicial conduct somewhat to comply, but I think it's a fine line between announcing what you generally believe and how you would rule on a specific case, and the Supreme Court seems to have drawn that distinction. But one of the reasons that judges and lawyers adhere to their codes of conduct, and there's a separate one, of course, for lawyers, and there's one for judges, is that all states, I assume, have a disciplinary process, and if you violate the code of conduct for judges, you can be removed from office. And if you violate the code of professional responsibility as a lawyer, you can lose your license to practice law. So it's not just simply a code that says this is what you ought to do. There are some severe repercussions if you violate the code. And we have heard a number of cases involving lawyers. We've heard a couple involving judges in the state of North Dakota, and I'm sure that Chief Justice Cobb, Chief Justice Moon, Chief Justice Eidman from Idaho have all heard those cases. So there are some things that flow from that. I will tell you publicly my response to the Minnesota versus White, and particularly Justice O'Connor's opinion, and I have a high regard for her. But I think she wrote that concurring opinion And she came out of a state that elected judges, and she was a state judge, that she thought that if this got so bad, we'd all change the system and would appoint judges instead of electing them. And I think it was pie in the sky. I don't expect that to happen. But in essence, what Minnesota versus White said is there's absolutely no distinction. If you run for office, it doesn't make any difference if you're running for a judicial office or a legislative office or an executive office. They're all the same, and so therefore if there are any restrictions on judicial offices that aren't there for other offices, it's a constitutional violation. So that's it, and in some respects they are different. They are different because I cannot promise you that if I'm elected and you come before my court, I will vote on your side. On the other hand, I see nothing wrong with the legislators saying, yeah, if you vote for me, I'll introduce the bill you want. I think that's perfectly acceptable. But there are two different situations. Someone else may have some different opinions.
Chief Justice Cobb.
Kim, that's a great question because I think a lot of people still don't understand the dynamics behind Minnesota versus White. But I think it's safe to say, I think Jerry would say that most of the Chief Justices throughout the nation, as well as many members of the judiciary, have been very concerned about it. And yes, there has been criticism of the United States Supreme Court case because of it. But I think a really simple way to boil it down is if someone during the campaign, which of course I had, you always are asked questions, but ask what's my position on the death penalty. And I would tell them that my position on the death penalty is totally irrelevant, that I'm going to follow the law. If, for instance, I followed Minnesota versus White and said, well, I'm either for it or against it, then if I said that I was for the death penalty, then that voter might vote for me and then be appalled when I reversed a death penalty case. And that really is the thought behind it, is that judges should not be announcing their personal preferences because we will uphold laws day in and day out that we don't personally agree with. But it is the law. And that's where I think, we get into judicial independence. And the question about Minnesota versus White of now saying that judges have First Amendment rights and they can just go around and announce, their positions on any, question that's being asked has certainly had a negative impact on the courts and on judicial races throughout the state. Throughout the various states. And it's an issue, the judicial selection, that we really would love for I think, in certainly some states. Alabama is one of the 7 states in the nation that still has partisan election of judges. And my opponent ran an ad against me that said he was, anti-choice. He was pro-life, and that I had refused to announce my position on that subject. Well, obviously, I had not announced my position on that subject or any of those subjects because I do not believe, that it's relevant and is a basis for which, a judge should be selected, nor how we're going to ultimately rule. So, but I'm interested, though, to hear that you'd say that we don't, other branches of government just accept it and say, oh, well, the court did it. I don't necessarily always hear it that way. So.
We feel forced to, perhaps. Thank you. Good comments.
Kim?
Judge Caparelli. I'm sorry?
Kim?
Wave your hand. Yes, over here. Yes.
David Knudsen. I'm a district court judge in Minnesota. And, of course, the 2 chiefs that just spoke are absolutely right on that White case. And far be it from the lower court to ever disagree with the United States Supreme Court. So I'm going to agree with them, even though that came out of our jurisdiction. But the concern, of course, is where do we go from here? And I think it's some of the things we've discussed before. It's a clear understanding of the role of these different branches. And what I see after serving 12 years in the state legislature and now 4 years on the district court, it's amazing the misunderstandings between the branches and the role that those separate branches play in our government. So I think if you sit back and look at the White case was pretty clear. If you're going to have an election, you got to have an election, a real election. And so as the Chief Justice mentioned here, they're begging the question, is that the kind of way you want to select your judges? And what I tell people, I've got a totally different role now as a district court judge. I'm no longer representing people. I don't have a constituency. I represent the laws as passed by the legislature and the Constitution as passed by the people. And so they begin to understand a little bit, but I think that education process and what it seems to be what Justice O'Connor is embarking on in a big way now is more of a civic education effort has to be done, because even those of us in these respective branches don't have a clear understanding of the difference between our roles.
Judge Knudsen, I really appreciate what you just said, because as I've mentioned earlier today, I think that one of the real strengths of this enhanced understanding and communication that we're trying to accomplish at CSG through this kind of effort is to drill down a little deeper into exactly what you just said. You've served as a legislator, now you're a judge. You see differences, you see misunderstandings, and those of us in one body can never understand that complexity and that difference unless we speak with the other body, and that's why this is
Well, it's very interesting to start talking about the budget and folks, judges sitting around the table saying, well, don't they understand? Let's just issue an order and tell them to send us the money.
Very good. Judge Caffarelli.
I think there's a couple of different layers here. The first question would be, what is the nature of the disagreement with the Supreme Court's decision? Now, the Constitution has certain requirements. The Supreme Court has spoken on that. One way to criticize it is to say, I disagree with the analysis. Another way is I doubt their integrity. They are being activist when they do that. But I don't think that as a judge, I necessarily, as Judge Cobb was saying, that I have to agree with it or disagree with it. I have to comply with it. I'm on an intermediate court in Colorado. If our Supreme Court makes a decision that I think is flat wrong as a matter of analysis, it doesn't matter. I have to apply it. And I have to apply it with respect for the way they intended it. And similarly, when I interpret legislation. So I think there's a difference between agreeing or disagreeing with the merits of the decision, the quality, or being happy or unhappy with the consequences of it. I think too often citizens who are unhappy with the consequences attack the integrity of the decision. And so when you hear that judges are unhappy with that decision, do not read into that, I think, that judges on a whole are attacking the integrity of it. Rather, they're saying, we think that the consequences of it are not going to be good. Now, how do they say that, and why do they say that? And I think this goes back to what we were talking about a little bit about training. When you're in an institution and you've been in it for a while, you begin to better understand the role of the institution and the function of it and the importance of you as a person in that institution to maintain its legitimacy, to maintain its credibility. And hence, most of us that are already in the judiciary would say, this is a dangerous precedent because it has the risk of undermining the legitimacy and the credibility of later decisions by that individual. Now, if you have a person who is exercising his or her constitutional rights as recognized by the United States Supreme Court, and they've not yet been in the institution, and they're moving ahead for their personal interest to become a judge or justice, and not well respecting the institutional role that they will soon be playing and how this might affect that can be problematic. And so I go back to the notion of training. Each of us comes to our institution not having been in it before. And yet somehow or another you're expected to walk in and get on-the-job training. That somehow or another you're supposed to just know what the highest values of that institution are and how to conduct yourself in a way that's consistent with maintaining the credibility and the legitimacy of that institution. So I think that a lot of this goes around to training, that when we bring judges in, when we bring lawyers in as judges, they need to be trained on their new role. When legislators come in to the legislature, they need to be trained on their new role. And frankly, judges need to be trained on your role. And you need to be trained on our role.
Which is why we're here.
And which is why we're here. And I hope that we'll be doing more of that in the future.
Thank you, Judge. And